Great. Hi everyone, we're just waiting for a few people to move over from the Zoom waiting room, so we'll start shortly. And there are still people joining, so we'll just give it a couple of minutes. Great. Hello everybody, welcome to the Doughty Street webinar on judicial reviews in asylum support. My name is Ben Chataway, I'm one of the barristers here, and my job is to introduce the two speakers for the webinar, and the scarcely need an introduction. First, I'm delighted to welcome Polly Glynn, the managing partner from Deighton Pierce Glynn. And as many of you will know, Polly's got really extensive experience in holding the Home Office to account in asylum support cases. And you'll be aware that her firm is involved in supporting a number of frontline agencies through the PAT project in particular, which we'll be hearing about. And secondly, I'm equally delighted to welcome Simon Cox from Doughty Street, who's fairly recently returned to Chambers from the Open Society Justice Initiative. And as I expect many of you know, Simon's expertise as a barrister in asylum support is, I think, unparalleled. So we're really lucky to have those speakers. Now, just before we begin, a couple of things about the webinar. You'll notice that your video and your microphone has been automatically muted, and that's just to make sure that Zoom runs smoothly. And secondly, in terms of questions, we really are keen to hear your questions as we go along. But what we ask you to do is, instead of using the chat function in Zoom, if you look at the bottom of your panel, on the right-hand side, you'll see a question and answer function. And so if you've got questions that you'd like us to address, please put them in there, and then we can come to them at the end. And lastly, the webinar is being recorded, so it will be available on the website afterwards. So without more ado, I'm going to hand over to Polly. And Polly, I think you're muted.
Good start. Hello everybody. I've got a PowerPoint, so I'm just going to share my screen so people can see that. So I've been asked to talk about how failures to provide adequate asylum support can be effectively challenged by judicial review. The way I thought I would deal with this is first have a brief overview of the type of thing that you can use judicial review to challenge, and some examples of some common issues that can be challenged by judicial review relating to asylum support. And then talk about two different ways that DPG have used public law to challenge asylum support issues, one through the PAT project that we run, and also through some systemic challenges that we were involved with that were heard last week. So firstly, when is judicial review appropriate? It's appropriate for all decisions that can't be appealed. So if you've got any appeal rights, then you can't judicially review. But so no decisions that can to refuse support or terminate support, which can go to the Asylum Support Appeal Tribunal. But where it is really useful is for issues of delay or inadequate accommodation, or failures to provide accommodation, or delays in providing financial support, where there's no right of appeal. And also the complaints procedure that is, theoretically run by the Home Office is is woefully inadequate in its timescale. So there really is no other remedy, and that's when judicial review can be really useful. So the things that we're seeing all the time with asylum support that we could be and should be challenging by way of judicial review or public law proceedings. I've divided these into sort of 3 headings. The first is delay cases, and I mean by that delay in accommodation. The second is about the adequacy of accommodation. And the third heading I put is delays in providing financial support. So the delay cases, the type of thing that I'm talking about here is delay in making decisions on asylum support applications. So somebody makes an application for asylum support and then there's nothing and there's a delay. And meantime, they are destitute because you have to be destitute to be entitled to asylum support, and they're not getting any decision at all. So in that case, public law proceedings would be appropriate. Or you've got a decision. You've got a decision that someone is entitled to support, either Section 98 or Section 95, accommodation and support, or Section 4 or Schedule 10, but nothing happens. They're not being given accommodation. So that type of thing we're seeing all the time, where people are found to be destitute or clearly are destitute and have made an application, but nothing happens. They're not being given support. So what you need to think about when challenging this kind of decision is, how long should you wait? What level of delay is unlawful? There's not a sort of strict answer to that question. It depends on the situation of the particular client. But I think what's fair to say is, if somebody is entitled to asylum support and therefore found to be destitute, they are at risk of being street homeless and destitute. By definition, if you're destitute, you are at risk of that. And so therefore the Home Office should be making decisions promptly. And so although I would be, if somebody's in accommodation where they've been for some time, I would be not saying do an application to court that day. I would be saying do a pre-action letter straight away. There's no need to wait. The applications for support should be processed quickly within a couple of days, and if they're not, then I think a pre-action letter at that stage would be appropriate, giving 14 days turnaround. Obviously, if somebody is street homeless, then the turnaround will be much quicker and you should do a pre-action letter straight away. Similarly, if they're being threatened with eviction. The second thing I think we always need to think about is the immigration implications of the challenge, and that's particularly relevant for Section 4 applicants. So always check with your client and their immigration advisors, if possible, what's happening with their immigration case, because what you don't want to do is to be jumping up and down about asylum support and then realise that that has prompted the Home Office to make a negative decision when their immigration application wasn't quite together enough for the Home Office to make the decision on it. So you just want to be careful about that. I think with asylum support, it's really important, but often people's immigration cases are more important, and that's their aim, is to get the immigration sorted out in a sort of fair way. The third question I'm often asked is, how long should the reply in the pre-action letter be? And again, I've dealt with that slightly. It kind of depends on how urgent it is. If somebody is being threatened with street homelessness, then the reply can be very quick, within a few hours even. But if somebody has been in the same situation for some time, then the normal 14 days should be given. The fourth problem that I see often is what I've called the phantom pickups. And I don't know if anyone in the sector will be, going, oh yes, I know this. And this is where you have a client who is desperate to be given accommodation and is on at you all the time. And then the Home Office say, oh yes, well, the contractors have said that they went and they tried to pick them up, but they weren't there. And you think that doesn't sound true, because the client is desperate to be accommodated, so why wouldn't they be there if they had been informed? And then you have a dispute of fact, which, to be honest, is always very difficult to deal with in judicial review proceedings. So my proposed solution is, in any contact chasing up an application for support or chasing up a provision of accommodation following a decision to award support, you always be saying, please let us, either a frontline organisation or as a solicitor, know when you're going to pick up. Please can you give us 24 hours notice of the date of the pickup and the time and the whereabouts of the pickup, and say that all the time and straight away when you're dealing with the Home Office or the Section 14 or Section 98 team. And that way, although, to be honest, I've never ever seen the Home Office contact me and say, oh, your client's going to be picked up on such and such a day. And that's even when the court order has ordered that the Home Office must tell me or DPG when they're going to be picked up. They never do it. But on the other hand, that means that if there is a problem with the pickup or there's a phantom pickup, then at least you can say, well, I did ask you to tell me and you failed to do that. And that gives you something to fall back on when you're making an application to the court. And they go, well, we've tried to pick this person up 3 times, but they've never been around. Then you can say, but each time I've told you to contact me and you never have. And so that's on you. The second issue that we see a lot of that is useful to challenge by judicial review proceedings is about the adequacy of accommodation. Now, the Home Office have, when they've decided that someone is entitled to asylum support accommodation, the accommodation has to be adequate. It has to be provided with reference to somebody's disabilities if they're disabled. It has to be in an area that they consider as appropriate. It has to be safe. It has to be safe in the fact that it's not with somebody who's violent. It's got to be safe that it's not in a hostel where they are. We were just talking before the talk started about the hostel in Wakefield, where there's no soap, there was no hand sanitizers, no one was given any money to buy any of that stuff. And so there have been a number of cases of the virus there because of that. So that's not adequate accommodation. And so, and the accommodation needs to be accessible. So if someone is disabled, then the accommodation has to be appropriate for them. So when somebody comes to you and they say that the accommodation isn't adequate, what you need to think about is what evidence you have. So if they are disabled or they've got ill health or there's other circumstances, what evidence do you have about that? Obviously, sometimes it's really urgent and you just have to write the pre-action letter without anything. But if you can get supporting evidence from somebody else, some professional, then that is incredibly useful. I've put a link to the guidance, which is about the allocation of accommodation, and that's what the Home Office say that they're going to take account of. That mentions the concession about Helen Bamber and freedom from torture, and the type of things that they will take into account about education if someone's in an important school year, and that type of thing, family ties. Obviously, there is a policy to disperse, and so they will try and disperse outside the South East as possible, but there are a number of reasons you can use not to be dispersed, and so adequate accommodation has to be in a certain area. The third thing to think about is whether the Home Office have made a decision, and that's really important when you're looking at whether the accommodation is adequate. Sometimes the Home Office will accept that accommodation has to be in a certain area or a certain type of accommodation, and a decision will be issued saying this. And then sometimes the Home Office then doesn't provide accommodation in accordance with their own decision. Well, that's a sort of easy challenge. Other times the Home Office won't yet have made the decision, so evidence will have been provided, but the Home Office won't have made a decision. And again, you can challenge their failure to take into account the evidence you provided when reaching a decision on what type of accommodation would be adequate. It's important when you're looking at the adequacy of accommodation to always think about how a judge would view this. And this is even when you're doing a pre-action letter. And I always try and imagine in my head as sort of some, old, white, posh man thinking about it and trying to persuade him of why it's important for my client. So things that might be obvious to you working in the field, things like sofa surfing, where we all understand what that is, we all understand how it works and how difficult. And so we all understand when the pandemic came out, you know, how that was going to be a problem and how people weren't going to be able to sofa surf in the same way. But think about some old white man might not get that. They might not understand what sofa surfing is. They might not get it. So always try and draft everything with a view to some old man reading this and getting persuaded by your arguments. Again, I put, always think about the immigration implications. I've talked about that in the last slide. And then the final thing is, how long should the reply to the PAT be? So if it's about moving from one area to another and it's not that urgent, then 14 days is the normal reply date and that should be given. On the other hand, if it's where someone's health is at risk, serious risk, whether there's violence or risk of a pandemic, risk of virus or something like that, then the reply can be much, much quicker. So that's a sort of, see how it is. I mean, there's nothing wrong with putting a too short reply date on your pre-action letter, and then even if then when you come to get legal aid and take it, a little bit more time would have elapsed anyway, and you know, further time can always be given at that stage. The third issue that we're seeing a lot of and challenging by way of judicial review as it comes to asylum support is delays in financial support being given. So this is where somebody's family makeup changes, where somebody becomes pregnant, a new child is born, and you get a little bit more money, you get a maternity grant. Obviously that's really important when you're pregnant or when you've just had a baby, and to, you know, for it to come 6 months later isn't quite as useful. So that's the sort of thing that you could challenge by way of public law proceedings. There's also seems to be an increasing problem recently about people being allocated accommodation under Section 4, being given the accommodation but not being given an ASPIN card. And that obviously leaves them in accommodation without any food or money. So that's a problem. Again, that can be challenged by public law proceedings, or where someone has lost their ASPIN card and there's a delay in producing another one. Again, think about how long you should wait, how much delay is unlawful, and with, you know, if you're not, so say with a maternity grant, you might want to give them a couple of weeks to process the application, but after that you might want to do a pre-action letter and give 14 days. If somebody's given accommodation and they don't have any money for food, then you will want to give them far less time, and the pre-action letter would be with a very quick turnaround. The type of evidence you'd need to pursue this, it's always really useful to have evidence of hardship if there is any. So if somebody's been going to a food bank and you can get evidence of that, or evidence from a social worker, or evidence of maternity, or the paper trail of chasing up the Home Office, all these things are useful. So I thought it would just be useful. There's a number of people on the call, and I'm aware that a lot of you will be solicitors and this will be very boring to you, but I just thought it would be useful for people who are on the call who are from frontline organisations, just to zip through very, very quickly the judicial review procedure. So the procedure works like this. The first thing you do is you do a formal pre-action protocol letter, which we call a PAP. The second, you have to give in that pre-action letter, the protocol says you have to give 14 days, but you can, as I've talked about in the previous slides, you can give much shorter time or no time at all if it's particularly urgent. After the time for the pre-action protocol has expired, if the response given isn't satisfactory, and that means if the response doesn't deal with the issues you've raised. So often they will say, well, we are going to provide accommodation. And you think, well, that's great, because you should have provided accommodation before and you've really said nothing else. The client is still without accommodation. That's not dealing with it properly. So it's only if your client is getting what they want, which is accommodation or financial support or whatever it is, that the protocol is fulfilled. The Home Office will often say the protocol is fulfilled when it just isn't. So don't believe when they say that this is the end of the proceedings and you shouldn't take any further case, because that's not true. So the third thing is then you apply for legal aid or refer to a solicitor to apply for legal aid. Once legal aid is granted, which should be within 24 hours, 48 hours, then you can issue an application in the court and ask for permission and interim relief. An interim relief means an interim order, and you would be asking for accommodation or accommodation and support, or support, depending on the urgency. The court can grant an interim relief within the same day, so if it's really urgent, that can be done. Or the interim relief could be granted within 3 days or 7 days, depending on the urgency. After the proceedings are issued, the defendant has 21 days to file an acknowledgement of service, and then the court will consider permission, and the court has to consider whether the case is arguable. The court will then give directions, and then it proceeds to a full hearing. So in the majority of cases, there's no need to go for a judicial review. The public law, the judicial review proceedings is useful for drafting a pre-action protocol letter. So in 85% of the cases that we monitor, a pre-action protocol letter results in the Home Office conceding and accommodation or support being awarded. So in about 15% of the cases, the pre-action protocol letter doesn't work, and then proceedings need to be issued. Once proceedings are issued, it's incredibly unusual for the case to progress beyond an order being made for interim relief. So usually what will happen is an order is made for interim relief, and then the Home Office try and settle the case on the basis that they pay your costs or that there are cost submissions. Occasionally, you'll have to get the court to order permission, but then the case is stayed. It's very rare for it to go any further. The Home Office don't want it to go any further. And that's because the cases that I'm talking about are asylum support are incredibly straightforward. The law says they've got to provide support. They're not providing support. What can they say? They really don't want the court to look at this in any detail. So I thought then it would be useful just to talk about the two ways, or two of the ways, that DPG are using judicial review in this area. And the first way, they're sort of very different, but the first way is the PAT project. And that's a project concentrating on the writing of pre-action letters. We found that there were a large number of unlawful decisions being made by the Home Office that couldn't be challenged because there just wasn't capacity among solicitors to take on the cases. And that was leading to a number of people being in a situation where they were destitute or sofa surfing, or really, being subject to really bad decisions by the Home Office where there was no way they could challenge it. So the PAT project, what it does is it trains and supports frontline organisations to write their own pre-action letters. So we've drafted a number of precedent letters. And once you've done the training as a frontline organisation, then you can fill in the precedent letters in the gaps and email them to DPG solicitors. We then check them to make sure that they are legally okay, and then the letters go out from your organisation, and 85% of the time, that's the end of it. The client gets accommodated or gets support, and that all works. And in the 15% of time that it doesn't work, then the matter gets referred to solicitors. And we have found mostly that we can get solicitors to deal with it, not DPG necessarily, anybody can deal with it. And the solicitors quite like it because it goes straight into court, which is always fun as a solicitor because we like going to court. The scheme's funded by the Big Lottery and Bearings, and it's being run with the British Red Cross initially, and then there's another scheme that I'm running with the Asylum Support Appeals Project. Anyway, if this is a bit of a plug, so if you're interested in joining the scheme in your frontline organisation, then do get in contact with me. Or if you're a solicitor and are interested and you do a lot of this work and you haven't heard about it and you want to talk to me about, how you can be taking the referrals, then again, get in contact with me. I think it's a really good thing, and it does mean that less unlawful decisions are being made, and a large number of people have been housed or provided with support as a result of the scheme. So sort of at the other end of the spectrum, the second way that DPG have been using public law is trying to challenge the way the scheme is running on a sort of systemic issue. Section 4 delay, I think if you work in the sector, you'll know this has been a real problem for a number of years. I'm sure that anybody who works for a frontline organisation will have been to a number of meetings where everyone sits there and talks about Section 4 delay and how difficult it is and what we can do about it. And I certainly have been to a number of meetings like that. And I think my first attempt to challenge this was about 4 years ago in court, where I got a concession that they had to monitor Section 4 delays, which they haven't done. I had another go at it, and there was a 4-day hearing last week about the problems with delay. So, just a second. The way that I just thought it would be interesting, and also just because it's when you are involved in a case, it's quite hard to think about anything else. I thought I would just talk about the background and how we managed to do this delay case. The problem with it was that, as I've said, usually with Section 4 delay cases, you do a pre-action letter and they settle it, and if you get it into court, they try and settle it straight away. So it's very difficult to either get it into court, or once you have it into court, to get the court to look at it as a systemic issue. Refugee Action in Birmingham wrote a letter, a pre-action letter, as part of the PAT project on behalf of 20 clients. So it was one letter sent on the same day on behalf of 20 clients. And on the day the pre-action letter expired, I think about 15 of those clients got accommodated that day. So that was a sort of fairly normal, 80% or 85% of the people got accommodated as a result of the pre-action letter. The ones who weren't accommodated, we issued proceedings for, and the clients were happy to try and challenge this as a systemic issue. We got some evidence from a number of frontline organisations about the fact that this was an ongoing problem, it was a systemic delay, and it was causing a lot of hardship. We got the case issued, the interim relief was granted, and we managed to persuade the court that this was enough of a systemic issue that the claim was allowed to continue despite the individual clients having been given accommodation. At the same time, my colleague Sasha Wazansky was issuing a separate case also about Section 4. And this was for a client who had disabilities and needed a particular type of accommodation. And the Home Office, although accepting that the client did need a particular type of accommodation, took 8 months to identify appropriate accommodation, 3 different relocations, 4 different properties, 2 sets of judicial review proceedings, 3 applications for urgent interim relief. Again, evidence obtained about the systemic nature of this issue, that this wasn't a one-off, that a number of applicants with disabilities were not being provided with adequate accommodation. And the case was issued, and again, Sasha managed to persuade the court this was enough of a systemic issue for the claim to continue even after the client had been given adequate accommodation. Both claims also involved a claim for damages. My one under Article 3, and one of the clients had disabilities, so also under the Equality Act, and Sasha's claim under the Equality Act. So I just thought for the people who were interested, I would explain a little bit about the arguments that we were running in the cases. What we were saying about the delay, so this is a delay after a positive Section 4 decision. We were saying basically the law says in Section 4 that you should be given accommodation. That's the idea of Section 4, is you should be given accommodation if you're destitute and you can't leave the UK and you're a fellow asylum seeker. And what the Home Office were doing, how they were running the scheme, didn't work. They weren't doing what Parliament said that they should do. So that was my, the straightforward argument, that their policy was going to be unreasonable and unfair, that there was a potential breach of Article 3 in all cases and Article 8, and also the common law protections against people being made destitute up to a sort of street homeless and destitute, as opposed to destitute in the context of migrant support. And then because of that, there were protections that meant that the Home Office had to be running a system that worked and not risking people being street homeless. And also then there's the Equality Act duties. Sasha's case was really at its simplest, that people with disabilities faced a worse service from Section 4 even than people without disabilities. So although people without disabilities had a pretty bad time, a lot of the time, in getting accommodation under Section 4, if you were disabled, it was even worse. And so they were saying that was in breach of the Equality Act. Both cases were vigorously defended. And the hearing was last week and it took 4 days, and we're expecting judgment in the late summer or autumn. So I will obviously keep everyone updated in the usual channels. Just as a sort of offshoot of that, in the claim, the Secretary of State referred to statistics in the National Audit Office report about how the contractors, Mears and Serco in Clear Springs, were doing with their contracts to provide asylum support accommodation. And the statistics that they produced in the court hearing sort of changed on a daily basis. But where they seem to have ended up is around the statistics that are in the National Audit Office report, which is worth having a look at. And I've given you the reference, and it's page 32 of that report. Why it's interesting is that they're quite astonishing, I think. For example, in the Northwest, it says that 98% of the time, from January to March 2020, people were given accommodation within the timescales. And we had evidence in our case of the Refugee Action Office in Manchester, where only 28% of their clients who had applied for Section 4 support had in fact been given accommodation within 14 days. So it seems to me that the National Audit Office are relying on statistics that aren't true. And I think that's quite serious. And I wonder whether that is in fact the root of the problem with Section 4 delays, is that how the contractors are reporting back to the Home Office, and the Home Office monitoring of those contracts, something has gone really badly wrong, so that the monitoring doesn't reflect what's actually going on the ground. Anyway, it underlines for me the importance of us as a sector monitoring delays and making sure that we always have the statistics so that we can, when we are going to court, we can produce something in reply to what they're saying. Otherwise, it is very difficult, because we have examples. We can all produce lots of examples of delay and how shocking it is, but they can go, oh yes, but you're one of the 2%, and the rest of them is fine. So it's not really a systemic problem. So it is really, statistics are all in these cases. So going forward, what we can do, I think, just to reiterate that point, we should all continue to collate information about delays and problems with asylum support. I think we should all be looking to do pre-action letters as much as possible and not letting the Home Office get away with anything. They should be providing people with accommodation who are destitute. If they're not, then we should be challenging that by a pre-action letter and then judicial review if that doesn't work. But mostly pre-action letters will work, and that should be done. I think we should be looking for particularly awful examples of problems for use in litigation strategy, and also think about publicising these as well. I think some cases are so awful that even mainstream media will be shocked. So I've given an example of the hostel in Wakefield, where there was such bad social distancing that was possible that so many people have now been infected with coronavirus there. It's completely shocking, and I think any right-minded person would think that was completely shocking, and we need to make sure that people outside the sector realise quite how bad these things are. And then finally, just to continue to share information as a sector, I think one of the really nice things about working on this case and working in this area for so many years is how collegiate everyone is, and how much people share stuff and share ideas and what cases they're doing and challenges. And I think we should continue, because that's our strength really against what can be an absolutely appalling problem from the Home Office. Thank you.
Shall I start then? You're muted.
Yes, that's me finished.
So Ben, shall I go, or are you going to, do you want to say?
Sorry, I'm randomly hitting my space bar thinking I'm unmuting, but I'm not. Please do. No, we're now going to hand over to Simon, thanks.
Okay, thanks very much. So hello everybody. I'm going to try and pick up where Polly left off and elaborate on some of the things she's talked about. I think I just want to mention first of all, I mean, certainly Polly's point about collegiality, but also that these problems are really very long standing. The Home Office has never been equipped to run an emergency service for accommodating a range of vulnerable people, and it's never stepped up to the mark in order to be able to accommodate them. It's gone through a series of attempts to palm that off onto other people, and its latest iteration, which is where we are now, is of a thin Home Office sitting in the middle, trying to take the decisions, and passing on responsibility to, on the one hand, migrant help as its first port of call, and then in the back office to Serco and MEARS and the other accommodation providers. And the contracts that they've been given are billions of pounds worth of contracts. And from what we can see, as Polly said, certainly for those of us working with individuals who are not getting into that accommodation, the statistics that Polly quotes don't stack up. And so that raises a number of problems that we can face in the judicial review, which is that the Home Office often doesn't know what's going on, and that the other people involved don't know what's going on. So, for example, in the judicial reviews that I've done recently, we have discovered from what the Home Office and what Migrant Help have said, that, for example, the Section 4 and Section 95 email address that people send their applications to, that says Migrant Help on it, that's in the email address name, isn't a Migrant Help email address at all. It's a Home Office email address, and Migrant Help don't have access to it. And so in another judicial review where we were being told to contact Migrant Help by the Home Office's lawyers, by the Government Legal Department, we did contact them, and they said, well, as far as we can see, your client's not on a list to be given any accommodation. And when we later pointed this out to the Home Office, they said, well, Migrant Help don't have access to that computer, part of the computer anyway. So we're talking about a system that is almost set up to be dysfunctional, because it's dividing decision-making in the Home Office from implementation in other parts, but it's also dividing up the knowledge of what's actually going on. So I think that makes our job especially difficult. I wanted to just comment on some of the, just to do some structured comment on some of the things that Polly was talking about. I'm just going to try and share my screen. Here we go. Bear with me. Okay. So I just wanted to talk from a, no, there we are. Apologies. I'll get there in the end. Right. Okay. Just wanted to talk from a practical point of view about some of the issues that solicitors may face in terms of preparing claims. And then I want to come on to some of the legal framework that we can use in that claim. But I think it's also interesting for people on the call who are advice agencies and for potential clients or people supporting people in this situation to know the kind of things that the lawyers if they should be doing on your behalf, ought to be doing on behalf of the asylum seeker client. So and it's not a comprehensive checklist, it's really a few impressionistic things that I have from doing some of this work. The first thing is that the kind of evidence that's really going to win the case in the court is detailed evidence from the client about the particular problems they're facing. And I think that it really helps judges if people are allowed to speak for themselves and say, for example, the food's so terrible that I go to bed hungry every night. Or every time I try and use the bathroom, there's a queue of 2 people outside coughing without masks on. Or in a case that I've done recently, my client was so frightened of being in the same space as the other people he's sharing accommodation with, that he was climbing out of the ground floor window of his room so that he didn't have to walk through the corridor. And I think that's something that really takes the judge and puts the judge kind of right in that hostel. So clients talking about how the space is dirty, about how there isn't soap. These things can sound petty, or they can sound very personal, but actually they're really convincing. And I think they're really important to motivate judges to do the right thing, but also to motivate the lawyers who act for the Home Office, to motivate other people who read these documents. These things, when you work on the side of the people who should be fixing this, these things are painful and they're embarrassing. And I think it's important that people are confronted with that. Secondly, it's helpful, certainly as counsel, to know enough of the immigration history. So I'd like to know when the appellant arrived in the country, I'd like to know where they arrived, and I'd like to know where the asylum claim is at. And if there are documents to support that, that's great. And the reason I want to know that is not because it matters very much for what kind of support they need, probably doesn't, but those are the kinds of details which can reassure a judge who may never have seen one of these cases before, that they're in the hands of a legal team who are making proper disclosure, who are telling them all the relevant facts. And then the second point there is also the asylum support history. So the documents that show when Section 95 support was granted, when other requests were made. Clients may not have kept these, but they may have kept some of them, or you may be able to, if you're a solicitor, you may be able to get them from a voluntary organisation that's been helping the client. And then we want the clients clear instructions about what they want, what's good enough for them. And they need to be empowered and emboldened to understand what we might be able to get, but also to be advised realistically about what we won't probably be able to get, that we won't probably be able to relocate them to the part of the country they'd like to be in, except in very rare cases. But we may find it relatively easy to demand that they should have soap in the common bathroom. That's the only bathroom that they can use, or that they can have hand sanitizer, or that they could be provided with masks. Organising the claim. For me, the asylum support claims are in judicial review are hard to do unless you're going to do them initially. And we're talking now down to the issue of the claim in a relatively intense period. Even though the issue may not be necessarily super urgent, the problem is that if you look at dealing with them in a more relaxed time frame over a week or two, by the time you get to the stage of actually issuing the claim, you'll often find that the Home Office have very belatedly accommodated your client or provided the Aston card. And then you'll have to stop and you won't be able to issue the claim. So in my view, it's ideal if everyone can be involved and be available for a relatively intense period of a day or two when you're expecting to issue the claim 48 hours after you start that last process. So it's a problem, presenting it as an urgent problem, you've got all the evidence that you need that's ready to go, and then you go for it, and you go from starting to prepare the judicial review claim to actually getting it into court before anybody has moved the target too much. Because these are also moving target cases. So I've been dealing with a case where the client was in accommodation that wasn't adequate, A PAT letter was sent, so he was moved to other accommodation that also wasn't adequate, but they also took his cash away. So then we had a new problem. And it's much more efficient if you can do that in a short time frame, but it's also more efficient if people are talking to each other, perhaps involving the advice agency if there is one, so that we know what's going on. Nothing more frustrating than finishing the claim and then getting a phone call to say, actually, the client was moved into accommodation yesterday, but nobody knew. But also, some of these claims might, as Polly's and Sasha's claims have, go all the way, and they might become important. So it is important that if you're counsel involved, or if you're solicitor instructing counsel, that you try to make sure that you've got all the arguments that you might need, even if you can't argue them out at first. So I include damages claims, but I don't argue them out in the initial claim form. There just isn't time in that very short time frame. And I say that to the court in the claim form. Oh, sorry. Let me just restart that. Okay. So following through, just to pick up quickly on the point that Polly made about the potential for a very small minority of these cases to go past the stage of just getting the immediate relief. I mean, the first point here is, of course, our overarching duty to the clients of confidentiality, that we have a duty not to share anything that might identify them or be personal to them into the public domain. And even if what they've got in the case will be really useful for other people, it's still their case and they're in charge of it. But where the clients do want to share what's been found out in their case or to push it forwards in order to make a point about other people, then I think, first of all, I mean, disclosure is very useful. In each of these cases that we do, we find out more about how the Home Office system actually works and how it's breaking down. And declarations of the law that tell us what it is should be happening in other cases. And then lastly, for clients where they can be of use, damages. There'll be a word of caution about damages at the end. Looking then quickly at the law. So the first point here is that Section 95 doesn't actually say that people have the right to be provided with adequate accommodation, but what it does say is that people are destitute if they're not provided with adequate accommodation. So that seems to me to make it pretty clear that if the Home Office don't provide adequate accommodation, they're breaking their legal duties, because then the person is still destitute. Now, that leaves a big question about what adequate is, but it's at least a start. So in determining what is adequate, and again, these are the rules about looking at the accommodation that someone has that's not NAS accommodation, but I still think they're relevant to what we can ask for by way of adequacy. You'll see that the government, Parliament, has said that two things don't matter in themselves, that you share the accommodation or where the accommodation is. But that's not necessarily the end of the story, because while the regulations say that preferences don't get taken into account, just what I feel like having, what I want to have, don't get taken into account, they don't stop the Home Office from taking into account the person's individual circumstances as they relate to his accommodation needs. So these legal words really take us around a lot of stuff that, to me, in a sense, is kind of propaganda. Your preferences don't matter, location doesn't matter, sharing doesn't matter, but then bring us back round quietly at the end to the Home Office recognition that, well, actually, you know, to be a logical, rational government department, we do have to take into account the individual circumstances as they relate to accommodation needs. Now, you'll sometimes see it said that Section 95 doesn't impose a duty, Section 95 doesn't require the Home Office to accommodate people. Well, that's wrong. Since the 2005 regulations, which implement European Union law, there is a duty. So as you can see from that, if an asylum seeker applies for support and the Secretary of State thinks they're eligible, they must offer the provision of support to that asylum seeker. And so I think it's also therefore important that if you're arguing these cases out with the Home Office, with judges, that we keep reminding judges this is a duty. It's not a discretion. It may say may in the Act, but it's not a discretion. It's a duty imposed by the regulations. because judges take duties more seriously than they take discretion. And where does that duty come from? It comes from the EU Reception Directive, which is still in force as far as the UK is concerned until the end of the year. And it might go on informing the law after that. And what that directive does is require destitute asylum seekers to be accommodated to ensure full respect for their human dignity. And it also requires, when the government is achieving that, to comply with international law instruments which prohibit discrimination, which could include in particular here the Convention on Persons with Disabilities. The directive tells us that what has to be provided is for a standard of living adequate for the health of applicants and capable of ensuring their subsistence. And that must meet the specific situation of persons who have special needs. And so we see that the people who have special needs are vulnerable people. Now there's then a long list of who might be vulnerable, but it's not exhaustive, because what's required is the specific situation of vulnerable people, such as, and those are simply examples of people who are vulnerable. And in my view, that's rightly so, because actually any one of us could be vulnerable at any time. Any one of us could have a medical incident, any one of us could have a heart attack, could suffer some other form of infection, any one of us could become infected with COVID. And so in my view, that vulnerable people, then taken together with the duties that we just saw about the standard of living in the specific situation of people who are vulnerable, gives rise to a duty on the government to make sure that the accommodation is adequate for people's personal needs, and in particular in the COVID pandemic, their COVID-related needs, which may be that they are asthmatic, they have liver disease, they have diabetes, they have some other condition that makes them especially vulnerable to COVID. So I mentioned before the possibility of damages. We need to be cautious about the time. We've got very little time left. Sorry. We need to be cautious about the value of damages to our clients, because if they're on asylum support and they get ordered damages, then the Home Office may say, well, you can live off the damages now. You don't need your asylum support. So I think we need to be thinking inventively about structured compromises with the Home Office in terms of how that money is paid over, how it's labelled, and agreements about how it might impact asylum support. Obviously, the easiest cases from the point of view of damages to benefit the client will be those where the client has already been given leave to remain as a refugee or humanitarian protection, in which case the damages may still affect any social security benefits they're getting, but not in the same dramatic way. We've very little time left, so I just want, Ben, I'm just going to turn to the question that I was asked, or that you asked me to answer, from Brian. So Brian Dickoff says, many of our clients are provided hotel accommodation with inadequate food, not the cash cards, no kitchen facilities, and they can't pay other basic necessities like toiletries. Is this something that's been challenged? Brian, it has been challenged. I don't know of any cases that have reached a judgment on that issue. It might be one of the issues that comes up in the cases that Polly's been talking about earlier on that she's been doing. But in my view, the Home Office has a duty, first of all, to secure that the food is suitable for special needs. So, for example, if you have someone who is diabetic and they need to be given food that isn't carbohydrate heavy, and they need to have the option of having the food that's right for their health, but also that at any time, but especially in COVID, that there's a duty to provide sanitation products in the hotel, or to give people money to buy those sanitation products. And I think that judicial review is very appropriate for challenging failure to provide safe, hygienic environments for asylum seekers. We're seeing a lot of pressure on asylum support accommodation. We're not going to see people moved out into better accommodation, everybody. I think it's important to challenge that. Last quick point, the directive requires that you have the right of an appeal in all cases. And the directive, as I quote there, sorry, that's Article 21, distinguishes appeal from review. So I think that what that can give us is an argument that judicial review should more closely scrutinise the particular facts of these cases and shouldn't be the usual judicial review, hands off, what is it that the Secretary of State thinks is rational and what evidence is it that the Secretary of State has. But that's an argument that hasn't, so far as I know, been subject to any judgments. Back to you, Ben.
That's great. Thanks, Simon. We've had a few questions posted. We are short on time, so I'm just going to look at a couple of them. Firstly, there's an anonymous question. Can an asylum seeker choose where the accommodation should be provided, such as the children attending school or their local connections with an area? And of course, Simon's largely answered that. And unfortunately, there's the primary legislation that says no. Indeed, the Home Office must not have regard to preference. But that isn't the whole story, because it leaves it open to argue about adequacy. And I think the starting point is to look at the guidance. You know, you just Google it. There is detailed Home Office guidance that is not as complete as you might wish, but is useful. So, for example, there's an allocations policy that makes it clear that children in the last year of school or in an exam year ought not to be required to move school. So always useful to go and look at the guidance. And then one other question from Darren Middleton. I'm not sure this will be covered, but can the availability of legal aid and asylum support be covered, please? What does legal aid cover and what doesn't it? And I wondered, Polly, whether you could give us a brief overview of that.
So far as the public law challenges we've been talking about, legal aid would cover them completely. I think for, so I'm not sure about helping people apply for asylum support or going to the tribunal. I'm not sure about that, but for the public law proceedings, then legal aid would cover it, with the pre-action letters for legal help and then getting the full legal aid for the proceedings.
Great. Well, we've reached 5 o'clock. I think we'd better draw a line there. But thank you very much for everyone who's been attending. And thank you, Polly, and thank you, Simon. As I say, there is a recording of the webinar which should be available. And I think it should also be possible for us to post our slides on the Doughty Street website afterwards. So thank you for coming along. That's the end of the seminar.